welcome everyone, whether you're here live while we're saying this and simulcasting it, or whether you're on demand throughout the course of the coming year. We are glad you are here. We are going to have a panel discussion today with four speakers on the topic of valuing lost profits in litigation. This is part of our valuation speaker program series, a multi-part program at Financial Poise. And what I'll do is I'll make a few housekeeping comments. I'll introduce our speakers, and then we'll spend almost all the time with a live active roundtable series of questions with our panel. So let me take care of some housekeeping things. I'll point out a few things in the slide deck, introduce our speakers, and then we will start our discussion. So today's program is brought to you by Financial Poise, and it's underwritten. Our financial sponsor is the National Law Review. It's a legal news website with in-depth analysis on a wide range of legal and business topics. A brief disclaimer: we're not giving advice regarding any particular situation. You should consult with your own legal or financial or valuation or damages advisor. Nevertheless, any of the panel members, any of us, including me as well, we'd welcome to hear from you with any questions you have. Our contact information is in the bios in the deck. So with that, it's my pleasure to introduce our faculty members today. We have Megan Beckwar. She's the principal of Dispute Economics in Philadelphia, Pennsylvania. She's very experienced in valuation, forensic accounting, and economic damages. We also have Richard Claywell. He's the principal of Richard Claywell CPAs based in Houston, Texas. Richard is a certified public accountant. He's also highly experienced in valuation, forensic accounting, and economic damages analysis. In addition, we have Barry Kaltenbach. Barry is based in Chicago. He's a partner with the firm of Miller Cantfield. He is a business litigation attorney who's very experienced in business and regulatory litigation. I am with the firm of HKA. I'm based here in Chicago. It just happens my slide is a little bit out of turn, but I do business valuation, forensic accounting, and economic damages work as well. And we also have William Amara. William is a director at Certum Group. He leads their litigation finance strategy. It's a litigation funding firm which underwrites certain types of litigation cases that it chooses to back. And so we have with us a mix of legal and litigation funding and forensic accounting, valuation, and economic damages expertise. And so we're going to hear from our panel, and we'll talk about lost profits, what they are, how they might be proven, how they might be challenged, and hear a variety of insights. One last thing I'd like to point out is the deck is here as your materials. So feel free as you'd like to review the deck, whether you want to do that electronically or take electronic notes, or you want to print them or download them. The slides are there for you as our participants to get additional information and to take notes. So we're not going to flip through the slides. Instead, we're going to hear from our experts and attorneys and our litigation financier. So with that, we'll start our questioning and we'll go around the electronic room here, sort of coast to coast, figuratively. A little different than you might see on cable TV because we're going to have interactive discussion. All right. So Megan, lost profits. We hear about a lot of different types of damages in business cases, but how do lost profits fit in and how are they different than other types of damages?
Thanks, John, and thanks for having me again. Lost profits fit in when you've got a situation where a business has, for some reason, due to the allegations in a complaint, usually earned less in the form of profits than they would have absent the event occurring. And lost profits can be additive to other forms of damages. Of course, the type of damages that are recoverable is subject to the claims, and you need to rely on, assistance from counsel to determine what those are going to be in any given situation. But it could include mitigation costs, for example, or there's a possibility it could be lost profits in addition to the ultimate destruction of a business. Or in intellectual property matters, you could have defendants' profits over and above lost profits. So they're a component based on the allegations that essentially you're trying to make the plaintiff whole, put them back in the position they would have been otherwise.
Well, thank you. Well, let's turn our attention just slightly different aspect of this. From a legal perspective, what types of cases might give rise to a lost profits claim? And then I'm going to ask also from an expert's perspective for some insight as well. So, Will, would you like to share some insight from the legal perspective as to what types of claims might generate a claim for lost profits? And then Richard, what happens if a company never made a profit? Does that make a difference?
Yeah, hey everyone, and thanks, John, and thanks for everyone for joining today, and Financial Poise for hosting it. It's a pleasure to be here. So I'm a litigator by training, and I work in litigation finance, and this is a great topic because a lot of times lawyers and claimants focus on just the liability, right? Am I right? Was I wrong? But you need to think about what are the damages, and also, frankly, can I collect those damages at the end of the day? So when we do an analysis of a case, we frequently start at the end, right? We look at damages and collectability. We think about damages in two ways, right? What was the benefit to the defendant, which is sort of the unjust enrichment analysis that we're not focusing on today. And then the harm to the plaintiff. What was it that they lost? The good thing for those who have strong claims is most causes of action tend to allow for pretty robust recovery of lost profits. So the first place you'll want to look is if you've got a statutory cause of action, trade secret misappropriation, patent infringement, copyright infringement, or maybe you have a common law cause of action, breach of contract. You'll want to make sure that the relevant cause of action, as provided by statute or case law, allows for the recovery of lost profits. And I think what you will find, subject obviously to the types of legal constraints that we'll talk about today, generally lost profits are available. There is, however, a very important second place that claimants must look, which is if you have a contract, those contracts very frequently contain important limitations on parties' ability to recover damages. So I would say default rule is most causes of action, common law, statutory, intellectual property, business torts, the types of cases we fund at CERTM, you're gonna be able to go after lost profits, right? And you're gonna want to call the folks on this panel here to help you think about those. But you need to look at the contract. Many contracts have limitations on parties' ability to recover speculative damages and sometimes specifically lost profits. Most state laws override those contractual limitations to the extent willful or intentional misconduct is at issue, based on a public policy rationale that we are not going to let parties contract around willful or intentional misconduct. The second place that you'll want to look in the contract is sometimes there is a specific damages cap in the contract that, again, you'll want to look to background law to see whether you could get around those. So headline answer is lost profits usually going to be available. You'll just want to check the statutes and obviously any party agreements to make sure that they're not limited in relevant ways.
Well, thank you. Richard, what if the subject business never made a profit?
If you've never made a profit, it becomes more problematic to show that you had the damages because the allegation is going to be you haven't made a profit, you're not going to make a profit, why are you here? So you need to look at various industry studies that are out there and what you've actually done Do you have a business plan, for example? And what does that business plan, your strategic plans set out that you're going to accomplish and to get to the point where you're going to make a profit? And are you taking those stair steps to get from point A to point B that shows that you are in fact making a profit? I'm said I'm going to do it. I'm showing you I can do that, and something intervened, and I no longer can be there. So that helps in being able to show that you could make a profit. You can't just go out there and say I'm going to do this. You never make a profit. I think you're going to have some real problems. You need to look at the industry data that's out there. What industry are you in, and are they comparable, pretty comparable to your business? And if they are, you could use that as a quote guideline to say, I'm in this particular industry. I've got this expertise. We can do whatever it happens to be. These guys are close to us. We're kind of following them a little bit from a percentage or revenue size for the particular business. Yeah, we probably could have made a profit if we'd have stayed in there. Do we have any contracts from the customers where there's some progression in there? We know we're going to get more contracts. How are we going to get more contracts? We have a reasonable certainty issue. Need to take a look at that to see if we would really have in fact made the profits related to that. You probably need to get a industry expert, depending on the industry that you're in. I know that for me, I'm a CPA. We do damages. We do valuations. I'm not an industry expert. I can't go out there and start testifying about industry. I can't testify about causation. That those are not my areas of expertise. So you probably would need to get somebody that really knows how to handle that and make a determination that you can make a profit, and then get with the client from my perspective and map this out. And again, using reasonable certainty, how can we get from point A to point B? And then we would testify to that.
Thank you, Richard. Barry, on TV, in the legal dramas, you hear, oh, your witness is not going to be allowed to testify, or your evidence cannot be introduced at trial. Well, is there something like admissibility, and does that affect whether an expert witness might be able to testify in a particular lost profits case?
Absolutely, although it's not usually quite as scintillating as an Ally McBeal episode, John. Thank you, and welcome to everyone. Yeah, the ability of an expert to offer an opinion on what a company would have made in lost profits, right, which by its nature is an opinion because we don't know exactly what it would have made. The test for that really depends on the jurisdiction you're in. The old basis, the historical basis, is what we call the Fry test. That was developed in the 1920s, and the issue there really is, has the expert's methodology been reasonably accepted by other experts in the industry? Illinois is a Fry state. California is a Fry state. I think New York is. The federal system in the 90s, really, and a lot of states that follow the federal model moved to what we call the Daubert test, which is also codified in Federal Rule of Evidence 702, which is a little more flexible and it's a little easier to prove lost profits under the Daubert test. The Daubert test looks for reliability. What it wants to be sure is that the expert is not testifying just based on their guess or their intuition or what they've seen in similar instances. They want the expert to be able to explain and replicate so that there are consistent results that can be tested. But the linchpin under both is reliability. Are the same set of factors going to give a reliable answer in case to case to case? Now, obviously, the amount of damages and lost profits is going to change depending on the underlying facts. But we want a baseline so that experts are not making it up as they go along. So in a case, an expert is going to have to be qualified by the court, which means they're going to have to show expertise, and then they're going to have to explain their methodology, how they came up with the lost profit number, and there's going to have to be an indicia that that is a reliable calculation.
Well, how certain is certain? How probable is probable? Is there something called a degree of reasonable certainty?
Yeah, in the law, all profits have to be proven, I think, in every jurisdiction to a reasonable certainty. And there's a great case out of, I think it's Oregon, where the court, I think it was the Supreme Court, said, we really don't know what that means either. What's reasonably certain? It's going to vary from one case to another case. There's a few rules of thumb, though. The first is that, and in particularly, this is to bear in mind if someone is challenging your computational lost profits. First, if it's pretty certain that there has been a lost profit, the law is a little bit more forgiving about calculating what the lost profit is. So you always have to prove that you would have suffered a loss of some sort, and then you have a little bit more flexibility to try to model what that profit is. The second is something known as the wrongdoer rule. And that is the defendant's always going to say, okay, Mr. Plaintiff, your profits were not proven with reasonable certainty. And the answer is, well, yeah, because you prevented me from doing it, right? You didn't sell me the widgets that I needed to incorporate into my product that I could have sold to my customers. You're now not allowed to attack me and say, but you didn't sell those things. So the active wrongdoer faces a tougher battle to try to say that, hey, I prevented you from doing something, but that's okay. Then we have something that I think Richard touched on earlier, which is the new business rule, right? And the new business rule used to be a new business can never prove lost profits. You know, the restaurant that never opened can never show lost profits because it doesn't have a track record. And I think by and large, that is now antiquated. I know Illinois recently did away with that rule. Businesses that have never been in business before can still show lost profits, but it can't be conjecture. It can't be an expert just saying, I'm going to ballpark it at this because I'm the expert. That's called the ipse dixit of the expert. But at the end of the day, reasonable certainty is not mathematical certainty. It has to have a reasonable basis, but it doesn't need to be proven to the penny that if you had made 43,000 sales over the next 5 years, this is the exact lost profit you would have gotten. There's got to be a basis there from which the finder of fact, whether a jury or a judge, can arrive at a number that's not just a guess. So it's a little bit lower of a standard than maybe it sounds.
Well, thank you. So far we've been talking about damages and experts. Well, to have a successful claim in litigation, are there some things that need to be demonstrated? Like if it's negligence, do you need to prove causation? Or if there's a contractual breach, do you need to prove causation? And if so, is that the damages expert's job or is that someone else's job? And so I'd like to ask Megan from the expert's perspective and Barry from the litigation attorney's perspective to share some insights. So Megan, what would you like to illuminate our audience with?
Sure, I'll go first. Yeah, Richard pointed out that causation is not something that the damages expert is opining on. So it's not in our purview to say whether or not the defendant caused the damage, certainly. But I do believe that it's very important to analyze the link between what is being claimed happened and the ultimate damages that are being established. And in effect, that is an analysis of causation from a financial perspective. There are a number of factors that could intervene that have to be examined, or, essentially it impairs the ability to testify to the damage with the reasonable certainty that is necessary. If, for example, I had a case not too long ago where the plaintiff claimed that their business was damaged in the first 3 years. And in year 4, they had all intentions of doubling the size of their operation. And therefore, they calculated the damages based on year 5 revenue taken out to 5 years. But in doing so, they failed to present any evidence of what their cash flow was originally in the first 3 years, what it was going to be, what the time frame was going to be on the build of this expansion, how they were going to obtain financing for it, how long it was going to take to fill that new expansion to capacity. So there's just so many steps between A and B that it would have been very difficult to come up with a properly supported causative link to the end result starting from where they did.
Barry, would you like to add some legal insight?
Yeah, as a lawyer presenting a lost profits case, I don't want my damages expert to touch on causation unless by miraculous happenstance they're truly an expert on the underlying issue, which I don't think I've ever encountered. William mentioned a couple of the types of causes of action you might see as like a copyright infringement or a patent infringement. I don't want my damages expert to testify that product A infringed upon a patent, for product B. That's not what you're an expert in. If you say that, you're just going to be attacked. You're going to have to admit on the stand you're not sure, and now your credibility's shot on everything, right? So you as a damages expert can assume certain facts are true. You can assume that a patent has been infringed. You could assume that a product did not meet certain specifications. You're allowed to do that in your report and in your testimony. You're going to want to say, I am assuming these to be true. And when you're cross-examined on that, you can just say, yeah, that's absolutely right. I'm assuming that that's true. And if it's not true, would that impact my damages analysis? It might well impact my damages analysis. That's perfectly okay. I'm not requiring you to prove my entire case for me. One thing that I like having a damages expert do, though, if I'm taking a case to trial, is sitting in the courtroom during the trial, listening to the testimony, and then they can incorporate evidence that is different than their assumptions. For example, if they're assuming that 5,000 units of a product would have been sold at a certain cost point, and the testimony at trial comes out differently, they're allowed under the law to sit there and listen. First of all, they're not going to be excluded from the courtroom like fact witnesses. Experts are usually allowed to be there, and they can adjust kind of on the fly their numbers a little bit so that when I call them, they can say, I've heard this testimony, I've updated my opinion, we've disclosed it, and now I'm able to give you a revised damages number even during the course of the trial. That's what I did in a trial we had last year where our expert sat there for 3 weeks of testimony, probably slightly bored out of his mind most of the time, but he was able to adjust on the fly. And then when they tried to cross-examine him on what wasn't in his report, he could say, you're right, but Mr. So-and-so or Mrs. So-and-so explained X, Y, Z, and I've accounted for that.
Well, thank you, Barry. Well, so far we haven't talked about how does a party, how does an attorney, ultimately, how does the expert get the information they need to evaluate and then develop an analysis and calculation. So I would expect that sometimes the party has access to a fair amount of information. Sometimes they don't, but they obviously don't have access to everything. So how do they get it? There's some way through the legal process that they may be able to get some information?
Yeah, great question. And it's connected to, the earlier question in terms of where does the damages expert sit relative to fact witnesses, relative to maybe you have causation witnesses. The way that I think about a litigation is you can analogize it a little bit to a movie set with the lawyers as the producer or the director organizing the whole show, and the damages expert, they're given the script, right? And they have their particular role to play. So how do they get the information? American courts generally have very liberal discovery rules. So to the extent information is in the hands of the defendants or even third parties, there are processes through the discovery process for the lawyers to go out, get the information from defendants. Otherwise, a lot of the information, especially when you're talking about lost profits, that's going to be information that frankly is already in the hands of the plaintiff, which puts you at a pretty nice advantage because you have a lot of time to work with your witnesses to develop those sets of facts. So usually, again, the lawyers are playing the role of custodian here, shepherding the information from the claim holder, who, to the point that was made earlier, hopefully would have had their business records, right, with business plans and projections and prospective contracts before, say, their trade secrets were misappropriated. Usually that's given from the litigants to the lawyers to the experts. It is important to be thoughtful and deliberate about how you work with your experts. That's really important. A lot of cases, you have your consulting experts and you have your testifying experts. And typically you'll want to consult with the consulting experts first, because the materials that are going to the testifying experts are going to be subject to relatively broad discovery, especially if you're in federal court. It would be under Federal Rule of Civil Procedure 26. So you need to be thoughtful and careful about what it is that's being handed over to the testifying expert. So a lot of times you have lawyers and claimants consulting with consulting experts in the first instance before materials are eventually presented to the testifying expert.
So what types of discovery for lost profits might occur?
Yeah, so you know, you'd probably go pretty broad, but you know, if you think about the type, you know, it would obviously depend on the type of case. Let's say you have a trade secret misappropriation case where you have a company that shared its trade secrets with a larger company in the hopes that the two would form a joint venture, go to market, and sell widgets for which the plaintiff company would have received a royalty, right? Well, for that, you'd want to go to the defendant and you'd want to say, okay, well, what were your internal projections at the time of this transaction and thereafter about how much revenue would have come to your company and how much royalties would have paid to the plaintiff company? No better proof that you can present at trial, in my opinion, than proof of damages in the defendant's own words. And then you kind of pull on the different strings that might come out of there, right? What did you actually do? How did you develop these trade secrets? What did you pitch to third parties about what they were worth? And then you'll do that both in the form of, you know, interrogatories, requests for production, which ultimately lead up to the depositions and trial testimony if the case is not resolved before trial.
Well, thank you. Richard, what is a damage measurement period? In other words, how do you know? Is the company damaged for a minute, for a year? How long's too long? So what is a damage measurement period and how do you tell?
That I think is a very interesting question, and I'm asked that quite a bit, and I try to explain it to clients. And I hate to say it depends, but it depends. It's all based on facts and circumstances, and I really hate that phrase. You are allowed the damages up until the point in time where you have recovered from the damages. Now, is that a week? Is that a month? Is it 6 months, 2 years? Therein lies a problem. So what you want to do, or what we do, is we have a thing that we call a pressures chart. And what this shows is what your financial performance was prior to the damaging event. When you recover, when your revenues or your profits get back to the point to where they were prior to the damaging event, you have recovered, you don't get anything beyond that particular point. So that gets to be a bone of contention because a lot of people that I've come up against don't use anything like that. And so now it's a matter of guesswork. Well, I thought they'd be in business 6 months after or a year after, you know, and you don't know. Is my methodology the best? I can't tell you that it is, but it works for me because I can explain to the court, here's how I got from point A to point B. Now we can argue about that relationship, but that's how I determine what that is. We had a case a number of years ago now where this company had been damaged and it was recovering. It was getting pretty darn close to where And we use regression in what we do, where we're going to get back to this line where we show that they had recovered. And I wound up showing that they never recovered. And the reason for that was about the time that they were getting real close. We're in the Houston area. We had a hurricane come in. Well, guess what happened to the company when the hurricane came in? They were out of business again. So I stopped it, the day before the hurricane come in and said we would have done whatever to get back to that recovery time frame, and the court accepted that. So it just depends on what you've got and how that works. I had a case 4 or 5 years ago. It was a fire damage case, and I asked the husband's wife. She was the accounting type person, if they ever kept any track of what they were going to do, and she had a detailed strategic business plan, whatever you want to call it, on what they were going to do and how long it was going to take to get there. And that particular time period was 8 years, believe it or not. And I did a forecast and damage calculation over an 8-year period, and the court bought into that. And the reason the court bought into that, I believe, is because she had that documented. They knew where they were headed. They had a fire. They had to start from scratch, but it took 8 years to get back to where they were. So it just depends. I don't think there's a magic number of months, years, or anything else. It's all based on facts and circumstances. And I'd love to hear what the attorneys have to say about that, or maybe even Megan, because it's a real difficult problem for us to contend with.
Yeah, I can chime in there, Richard. Really, it's difficult, normally if they've reached the point at which they were previously, then probably they haven't fully mitigated their damages yet because they were potentially on a growth trajectory. So it maybe fails to factor in a little bit of additional damage that could have been suffered. But essentially, another way of looking at it is how long would it take them to go out and replace the customers or rebuild the IP, or there's a number of ways that you have to look at it based on the claim, again, to put that person or entity back in the position that they would have been.
Well, thank you. Will, does every compensatory damages case have an expert to quantify damages? And how does a party know whether they need a damages expert and when to get that expert involved if they need one?
Most good cases do have them. I think it'd be hard pressed to find a case where you're going to make a conscious decision unless you're just really strapped for cash, which is what we do as litigation funders. You're going to want a damages expert, right? You're gonna need an expert who's going to be able to go through. Do you technically need one as a matter of law under most causes of action? Not necessarily, right? You can present information through your fact witnesses, but I would not recommend that for anyone, really. You want to have an expert who can take the facts and present them in a way that is going to be convincing to a judge, for Daubert purposes and for summary judgment purposes, and ultimately is going to be convincing to a jury, because the defendant, you got to bet if you're looking for a meaningful amount of dollars, they're going to have their own expert, and you have to show up, with your own. And by the way, sometimes there are different kinds of experts who are needed to put together the damages model. Let's say your lost profits theory is for a medical company that would have developed a particular type of drug. You're probably going to need an FDA expert, right? Who's going to make the argument that you would have gotten this drug approved, as well as the person who's going to be able to put the projected revenues and profits into a financial model. Now, some of those other experts kind of straddle the line, right, between liability, was a wrong committed, and damages. How much do you owe for that wrong that was committed? So I think virtually every case that I've worked on, there's at least one expert who's focused on damages, and frankly, very frequently more than one.
And at what point in time in a case,
Yeah.
is it at the beginning? Is it after discovery's closed? Was it wait until the other side testifies and then think about a rebuttal?
It
When
is
do
from day
you?
one. I mean, the way that we think about cases, and I'm sure that the way Barry thinks about his cases are, you prepare your case for trial, and maybe it resolves before then. And your case at trial, a critical foundation of your case at trial is expert testimony about damages. So when we are thinking about funding cases, right? A lot of times clients, law firms are already coming to us with a draft damages model prepared by an expert. That doesn't mean that that person is going to be the testifying expert, 24 to 36 months from now when the case is funded and makes it to trial. But you need to have at least that consulting expert doing a preliminary look up front. That can add a lot of value and is well worth the early investment. You always need to plan far ahead in these types of cases. You cannot just react, especially if you're bringing a case on the plaintiff side. If you're a defendant, the calculus might be a little bit different, but as a plaintiff, you need to be planning everything far ahead because everything from your complaint on forward is going to depend upon building towards that damages model at the end of the day.
Well, thank you. Megan, we heard about quite a bit from you and Richard and Will and Barry, and along the way we talked about like reasonable certainty, and we talked about admissibility, we talked about evidence and getting an expert involved. So leads me to ask, are there some standards? Like how do we heard like is the expert's work or their methodology generally accepted? How do we know? Are there some standards that we could check?
Yeah, I mean, Barry essentially covered the rules of admissibility is what you're trying to ensure that you fit within, because if your testimony ultimately is not admissible, then all the work that you've done is for naught, right? So essentially, in order to be qualified as an expert, you have to have knowledge, skill, experience, training, or education that sets you apart, allows you to be helpful to the trier of fact on a fact or understanding a portion of the case at hand. And you have to demonstrate that you've used a method that we used to refer to it as generally accepted, but now, it's the term is more reliable method, and it has to be reliably applied. So your damages analysis cannot be riddled with errors. It has to be a similar way that another expert would also apply the methodology. You don't want to be operating really outside the box a lot. It has to be replicable. So you have to use a lot of references so that another expert that picks it up and wants to assess your damage claim can recreate it just based on the documents that are in evidence. And it has to be based on sufficient facts and data that are in evidence.
So are there some like professional organization standards like the Society of Megan Beckwire that issues pronouncements on how to do this?
Well, not as far as I know, specific to lost profits. So you might get a CPA, you might get somebody that's a credentialed valuation professional that's going to be performing the analysis. You could get a master analyst in financial forensics. There's kind of a variety of different credentials that might be applicable in your case, given, the claims. If there's some fraud claims, you might want a CFE as well. But all of those credentialing organizations do have professional standards that everybody that holds the credential has to comply with.
Well, thank you. Barry, we've been talking so far as a claim that the plaintiff has, but could the plaintiff also have some conduct or negligence that might be relevant in quantifying damages?
Yeah, it depends on the nature of the claim. In a breach of contract claim, they're kind of binary, right? You've either breached a contract or you haven't. The concept of contributory negligence or comparative fault doesn't come into play. If there's a breach of contract, it does you as the plaintiff, it doesn't matter if you're also a little bit at fault. The point is the defendant breached. In a business tort case, for example, a tortious interference, things like that, a disparagement claim, for example, comparative fault can come into play there because it's a tort claim, not a contract claim. So you can say to a plaintiff, you didn't do a good enough job and you contributed in part to your own damage. And so if a jury or a judge determines that you as a plaintiff caused 15% of your own damage, then the damage number gets reduced by that 15%. That doesn't happen in a breach of contract case. It's just the economic model of the law. But what is applicable in a breach of contract case is the duty to mitigate your damages by a plaintiff. So as a plaintiff, once you are aware that you are suffering a damage, you need to try to minimize the damage. You can't just sit back and do nothing and say, okay, I want my lost profits for the next 5 years, for example. You need to try to get back into business. You need to try to open. Maybe, you have a restaurant, for example, that had a fire and there's a part of the restaurant, maybe the room that they were going to set aside for, weddings or anniversaries, maybe that's been damaged and that can't be opened for a period of time. That doesn't mean they can sit back, shut the restaurant and say, I'm entitled to all the income I would have made. You got to open the part of the restaurant you can open, assuming you can do it, and that's mitigating your damages. Now, what exactly you need to do to mitigate is a fact question dependent on every case. But as a plaintiff, you always, in a contract or tort case, have a duty to try to mitigate your damages. But in a breach of contract case, comparative fault is just, is not something that comes into play.
Well, thank you. Richard and Barry, I'd like to talk a little more specific about what are lost profits. So Richard, if the plaintiff's company is disrupted and it lost $10 million in sales, is that $10 million lost profits?
Well, no, it's not. There's a difference between revenues and profits. The revenues are going to be the sources of money that you bring in from the clients that you deal with. So that's revenues. That'd be your $10 million. Then we have the profits. The profits is what we have left over after we pay all of our expenses. Now, and this is the example I use all the time when I talk to people about a lost profits case. Take the hamburger stand down the street that you really like to go to, and they have a fire and their business is closed for a time period. They don't necessarily get all of their expenses related to that. What we have are things that are called either variable costs or avoided costs or costs I didn't have to pay. And so when you have this hamburger stand that's been burned down, I'm not buying hamburger buns. I'm not buying lettuce, tomatoes, onions, hamburger meat. So those are avoided costs. I don't have to pay those any longer. I do have to pay what I would call fixed costs. I still got to pay the rent. I may not have to pay utilities, but I got to pay the rent. So what winds up happening is you would take your $10 million in your example, you would subtract from that your avoided costs because you don't have to pay those. Then you would subtract your fixed costs, and that would be your lost profits. So it gets a little bit dicey to determine that because you probably don't have the accounting records where you can just look at them, in 1 or 2 minutes, you know exactly which costs are avoidable and which costs are not. So typically the damage expert has to go through there and try to determine which ones are which. There's some techniques we can use to do that. But just because you have a $10 million decrease in your revenues, that does not mean you have a $10 million loss.
And Barry, are we talking about gross profits? Are we talking about net profits?
So
Are we talking about net profits after tax?
That's the thing is, as Richard said, it's not a lost income claim, it's a lost profit claim. So we can't look at your gross income because you would have had expenses, and someone like Richard can help you figure out, what expenses would you have not incurred and what expenses would you have incurred. But I recently had a case where we had a business, it was a winery and it was in business, right? And so it's able to do a variety of things. But let's imagine you have, let's just say, a wedding hall somewhere. You have a beautiful vista and you have built the hall, you have the ability to have a wedding, and then you want to have a second wedding. And the second wedding is not being allowed. Maybe there was a fire, maybe something else happened. So now you can't have that wedding. So I want to try to figure out what is the income, so I can figure out what is the income I would have generated from that wedding, right? I know that I charge X as a facility rental fee, for example. Okay, but what are my profits off of that? And in the case we had, it came down to the issue of gross profit margin versus net profit margin. And that's a really significant difference. From our point of view, gross profit margin was appropriate, and that was what our expert testified. And the issue was there were not significant incremental costs incurred. So in other words, the client in my scenario has already built their wedding hall. That is in the cost of having their first wedding. Having their second wedding, they don't have to build another wedding hall to do that, so their profit margin can be much higher. I think in the pharmaceutical industry, there's a great example I remember hearing that kind of explains this a little bit easier. And that is, asking someone, why do you charge $10 for that pill? It only cost you, 40 cents to make it. And the answer is the second pill cost 40 cents to make. The first pill cost $5 billion to make, right? All that initial cost that goes in up front isn't necessarily going to be replicated every time you have something. So we were trying to get it, in my case, the difference between what is the profit margin to have the first event and the profit margin for a second event. And as the lawyer, that's not an area, I'm an expert in the law, I'm not an expert in profit margin. So someone like Megan or Richard would come in and kind of look at that, and then they make a determination on what would we have incurred going forward. But so that's why you are projecting by the very nature of lost profits. You can't just look at what's happened. You also have to have an opinion of what's going to happen.
Well, thank you. Megan, we've heard a little about having some projections available that were prepared perhaps during the ordinary course by or regarding the subject company that has a claim for lost profits. But are there some general categories of damage measurement methods for assessing the lost profits of a business? And could you provide us an example of a few of these methods and maybe tell us how they're a little different or the same as each other?
Sure. Yeah, if you have sales projections, that can be a good thing. If they were prepared internally and they've never been used or tested or given to a third party, and a bank hasn't lent you money on them, then they might not necessarily be a strong piece of evidence. So a lot of times small businesses don't prepare projections either. But if you do have a situation like a transaction, an acquisition, and the acquirer has prepared projections about what they assume the business unit that they're acquiring was going to perform like in the future, then that might be a really good piece of evidence, and that would allow you to use the sales projections method for calculating lost profits. Essentially, all of these methods are just different ways of constructing the but-for world, they call it. But for the damages, these would have been the revenues and expenses that we would have incurred. Another one, if you don't have projections or they aren't really a good reliable source, you would look to potentially market data. So you could use a yardstick approach, which is to look to competitors or other industry participants, engage, if we were performing at the same rate as these firms previously, and we had continued to, then this is where we would have been. Or there's also, the name of it is actually escaping me because it's so seldom used, but it is a market percentage essentially, that if you have data, like cell phone manufacturers might have data with respect to what proportion of the market do you control and how did that change. I don't frequently utilize that method because frankly, it doesn't apply to a lot of business types that I work with. The other one, there's a fourth, I know, and I'm looking at my notes, I'm sorry. Yeah,
I think you've covered the three most common ones: the before and after method, the yardstick method, the sales projection method. Well, yes, four, and the market model method. So perhaps you're thinking of the before and after.
that's right. I didn't call it out by name, but the before and after is the most prominently utilized, I would say, with small businesses in particular, because the data is readily available. You have what the business was doing before, and you may well have what the business was doing after if it has already recovered. But best practice, in my opinion, is to apply as many of these as you can. You try to collect all of the data, you determine which is going to be the most reliable evidence and what is going to produce the result that you're the most confident is correct.
Well, thank
And
you.
I think this is related to the point about having to prove damages to, only to a reasonable certainty. And I think what's animating that is this idea that where the defendant has been found liable, right, where they committed a tort or violated a statutory prohibition, the burden should not be on the plaintiff to prove their damages to the very specific penny. The burden is certainly on the plaintiff, right, to prove damages. But we sort of in a way relax the requirement only to the reasonable certainty, recognizing, to Megan's point, that there's a lot of different ways that this could play out. And just because there are a lot of different ways, that doesn't mean that we should punish the plaintiff because they didn't sort of get to live out the future that they would have absent the wrongdoing.
Well, thank you. Richard, we haven't talked about present value, and we haven't used those Latin terms ex post and ex ante. Does present value or ex post or ex ante have anything to do with the lost profits damages analysis?
Yes, it does. What winds up happening is when we have a damage, we want to estimate what the loss happens to be. But what we need to do is put that into today's dollars. So let me tell you how that works. Let's assume that you've got $100 that you put into your bank account and it earns 5% interest. Now, the math is not exactly correct, so excuse me on this. But the first year you earn 5%, so now it's worth $105. And then second year you make another 5%. And then a year after that, you make another 5%, then another 5%. So what winds up happening is over the next, say, 5 years, that $100 has grown to 125. So we are going to make a projection, a forecast of what those revenues are going to be or the profits are going to be. And we say, well, look, we estimate those to be $125. But what are they worth in today's dollars? And that's what we have to determine is what is that present value of that 125 today? Sounds pretty simple because I just use a 5% number. If you go to the bank or you read finance textbooks, they always talk about using a 6% number. And I'll ask employees when I hire them, where does the 6% come from? And nobody can ever tell me. And the math just works out easy as 6%. But you have to determine what that risk rate is going to be, whether the risk associated with getting those monies down the road is a 5% risk, a 10% risk, a 20% risk, or 30% risk. The higher that risk, the lower that present value is going to be. but we have to project this out to determine what that is and then get the numbers today. That's what the award will be, is what those numbers are based upon today, not the 125 that I had down the road. So depending on what the math would work out, if it worked out to be, say, 125, you might actually get 110 or 108, 107, 112, something like that. But that'll be what it's worth in today's dollars. And that's what we really want to try to get, is what is the present value? What is that worth in today's dollars?
So is it present value looking forward, or is it taking the prior amounts and adjusting them forward to today? Which way are we looking? Forwards, backwards?
What it does is you forecast or project into the future what we think the damages are going to be. And then we've got that, say, at 125. What we want to do is now back that up. So we go forward first. What are the damages going to be? And it's 125. Now, what's it worth today? Because it's going to take 5 years for it to grow out. But I want my money now. I don't want to wait 5 years to get it. So because I want it now, what is it worth in today's dollars? And that's what the present value is today's dollars, not the dollars 5 years down the road.
So sometimes is there an ex post versus an ex ante damages calculation? In other words, is it always looking at the lost profits from a particular point in time going forward, or sometimes is it measured as lost profits as they actually occur, whatever the market conditions turn out to be?
I think what you're asking is what winds up happening is when you have a damage out there, the company may have been damaged, i.e. a little bit. So now you've got some lingering losses that are out there. And now, and I'm thinking about from a business valuation standpoint, we actually have to shut the business down. So what we have is something that leads up to a quote final damage, if that makes any sense. And then those final damages will continue in the future. So you have some that you have happened before and some that you have happen after. You have to separate the two and come up with both of those to get what you're looking for.
Well, thank you. As we come down to our last 2 or 3 minutes of our program, I'd like to open the floor and ask each of our panelists if they have a brief 30-second a piece of insight they'd like to share in closing. So, Will, could I start with you?
Yeah, sure. And I'll go back to, to a point that I made at the beginning, which is in any litigation that you are thinking about pursuing, start at the finish, right? Start by thinking, what are the damages that I'm looking to get from a collectible defendant? And it is never too early to start thinking about how am I building my damages case? Because your whole liability theory needs to build up into that. And we see a lot of times clients who come to us, they've thought a ton about liability, but haven't linked that up to damages. And so that would be my one takeaway for folks, is make sure that you should start at the end. And if you don't start at the end, at least make sure that you're thinking about that whole piece of the litigation before you file your complaint, because it might be too late if you start thinking about it only once you're in discovery.
Sounds like perhaps you're thinking some of our audience should look up on YouTube the mid-1980s litigation case between the United States Football League and the National Football League. The original USFL, they actually won in their lawsuit, their antitrust lawsuit against the National Football League. They were awarded $1 in damages, which under antitrust law gets trebled. So they got $3 in damages. They also collected, I think, $6 million. They were awarded attorney's fees. But yes, whether in hindsight, whatever their damages expert situation, in hindsight, maybe 40 years later, maybe things might have been done differently. But yes, that's maybe a lesson learned there. So Barry would like to weigh in.
Yeah, sure. It's don't fall in love with your own internal projections. One of the first things I do when I'm hired is to question my client's own assumptions. When Enron was merging with Dynergy, I think it was, as it was dying, Dynergy's executives called up and said, wow, your growth projections for next year look amazing. You know, they're 20%. Can you send over your business plan? And the Enron executive said, well, we don't have a business plan for next year yet. It was, well, how do you know you're going to grow 20%? And he said, well, I took my last year's numbers and I increased them by 20%. Clients have a tendency, sometimes their internal projections are not realistic. Sometimes they are. But one of my jobs to come in is to test those. And that's why I want an expert involved with me right away. How can I start testing my client to make sure they understand the framework? And as Will said, I need discovery. I need you involved during discovery so I know what to ask for from the other side in discovery. What do you need me to go get you in a deposition or an interrogatory that you can use? So I agree with him. You got to get your expert involved early in a case.
Well, thank you. Megan, from the expert's perspective, what insight would you like to close with?
I guess, just really as a business owner, if you never anticipate that you're going to be involved in a scenario where you're going to be in litigation. But when it happens, if and when it happens, having clean records, just really, small businesses in particular, keeping the personal expenditures off of the income statement and reducing the amount of sifting and sorting the expert has to do is going to make for a lot more efficient analysis and process when you ultimately need somebody to come in and review that document.
Well, thank you. And Richard, we'll ask you for the final insight.
From a damage expert, and I know and I understand this is not all the time the attorney's fault, but I had an attorney call me about 2.5 weeks ago. It's a lost business value case, not a problem to do it. Got some information on it, and I said, well, do you have any deadlines out there that I need to be aware of? And he said, yeah, I need to have the report in 2 weeks. And I, yeah, I see a couple smiles out there. And I just told him, man, I can't do that. If you give me 90, 120 days, I can do it, not a problem. And I know that, you're just not ready to pull the trigger on that yet, but the attorneys and the clients need to understand that, we've got other things that we're doing. And you may not be able to find an expert to get it done if the client has not authorized that you get that done earlier. So I guess give us a break, and make sure we got plenty of time to get done what we need to do. I'm not going to put something together half, what. I mean, it's going to be something that I can support. And if I can't support it, I'm just not going to do it.
Well, thank you. Richard, Megan, Barry, and Will, we appreciate your time and your insights. And to our audience, thank you everyone from our audience for spending some time with you. We know your time is valuable, and we hope that you found this not only helpful, but interesting. As I mentioned at the outset, our contact information for each of the 5 of us is in the deck. We'd welcome hearing from you. And with that, thank you again from Financial Poise. And this concludes our webinar. We look forward to seeing you on another Financial Poise program. Take care. Bye-bye.
Thank you for having me. Appreciate it.